The House will come to order. The Pledge of Allegiance will be led by Sally Aguilar, Matthew Phillip, Jelaya Rodriguez, and Adrian Guerrero.
Please join us for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Schiebel, please call the roll.
Representatives Bacon, Barone, Basenecker, Bottoms, Bradfield, Bradley,
Good morning.
Brooks, Brown, Caldwell, Camacho, Representative Camacho is here. Carter, Clifford, DeGraff, Duran, English, Espinoza, Ferre, Flanell, Rep. Flanell is excused. Froelich, Garcia, Representative Garcia is excused. Garcia Sander, Gilchrist, Goldstein, Gonzalez, Hamrick, Hartsook, Jackson, Johnson, Joseph, Kelty, Leader, Lindsay,
Here.
Luck, Lukens, Mabry, Marshall, Martinez, Morrow, McCormick, Wynn, Pascal, Phillips, Richardson, Representative Richardson is excused. Ricks, Representative Ricks is excused. Rutinel, Ryden, Sirota, Slaw, Representative Slaw is excused. Smith, Soper, Stewart K, Stewart R, Story, Sukla, Taggart, Titone, Representative Titone is excused. Valdez A is excused. Velasco, Weinberg, Wilford, Winter, Woodrow, Woog, Zokai, and Madam Speaker.
I heard Weinberg yelling. I'm like, what? It's impossible. How did you do that so fast? Yeah, why am I seeing the camera?
Thank you, Mr. Schiebel. With 61 present, 4 excused, we do have a quorum. Representative Goldstein.
Thank you, Madam Chair. It's a pleasure to serve with you.
I'm sorry, again, Representative Goldstein.
Thank you, Madam Speaker. It's a pleasure to serve with you.
It is a pleasure to serve with you.
Madam Speaker, I move the Journal of Monday, March 2nd, 2026 be approved as corrected by the Chief Clerk.
Members, you've heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye. All right. All those opposed, no. The ayes have it. The motion is adopted. Members, we're going to start with announcements and introductions. Members, we have a phone for sale up here at the desk. Someone left it. It has all of your favorite passwords and photos. Aha! Rep. Joseph. Thank you, Mr. Schiebel. Members, announcements. Representative Goldstein.
Thank you again, Madam Chair. I would like to introduce my guests today. I have students from North Glen High School and 3 of their teachers, and 4 of those young people were the ones that led you with the pledge. So welcome them to here today.
Thank you, Rep. Representative Lukens.
Thank you, Madam Speaker. The Outdoor Recreation Caucus lunch is tomorrow at 12 noon at the State Services Building cafeteria, and everyone is invited. And then we are also taking our winter field trip to Echo Mountain, and we'll leave at the east side of the building of the Capitol at 3 o'clock and be back around 8 if folks would like to come tubing and skiing tomorrow.
On what snow? Great snow, on great snow. Representative Gilchrist.
Thank you, Madam Speaker. The Health and Human Services Committee will meet 15 minutes upon adjournment to hear House Bill 1238, 1194, 1277, and 1280. See you there.
Great. Representative Barone.
Thank you, Madam Speaker. Members, good morning to everybody. I would like to welcome members of the NFIB, the National Federation of Independent Business, to the chamber. They're over here on to my right. Please welcome them.
Hello. Good morning.
Today is NFIB is holding their Small Business Day at the Capitol. NFIB is the largest small business advocacy organization in Colorado. Approximately 6,000 members who live and work in communities all throughout the state and operate in all types of industries, including 150 members in House District 48. Small businesses are the foundation of Colorado economy, and nearly half of all employed Coloradans work for a small business. I am proud to represent many small businesses in my district, including my father's and my own, and applaud the role they play in our communities. Small businesses are not only the foundation of the economy, but also the fabric of our communities, and help define them with their character, innovation, and uniqueness. There are many small businesses in my district and in very diverse industries, from coffee shops to construction and auto repair to framing. I would like to welcome NFIB members who are on the floor today. We have small businesses owners from Boulder, Centennial, Colorado Springs, Craig, Grand Junction, Highlands Ranch, and Longmont, and their businesses range from retail to restaurants and technology sectors. Thank you for being here, and please say hi to them if you see them throughout the day.
Thank you, Representative. Representative Mabry.
Thank you, Madam Speaker. Judiciary Committee members, in room 107, 10 minutes upon adjournment, we will be hearing House Bill 1012. Please be there on time. And also would like to announce that the Majority Leader has given me permission to be excused tomorrow and Thursday.
So approved. Representative Froelich.
Thank you, Madam Speaker. The Transportation, Housing, and Local Government Committee will meet 10 minutes upon adjournment, LSBA, for three bills, 1202, 1257, and 1192.
Thank you. Representative Stewart and Taggart.
Thank you, Madam Speaker. Today, we recognize people with intellectual and developmental disabilities and the community of family members, researchers, advocates, educators, providers, case managers, and advocacy groups who work together to ensure that they have the supports they need to be fully included and live meaningful lives in their communities. People with IDD are defined by their strengths, abilities, and inherent value, not by their disabilities. With appropriate resources, services, and personalized supports, they can make decisions about their own lives and meaningfully contribute to their communities just like people without disabilities. Thanks to the work of the IDD community and state policymakers, we have made significant progress towards ensuring that everyone with IDD has access to the supports that they need to reach their full potential. However, despite this progress, many still experience barriers to integration, employment, healthcare, education, housing, and other aspects of community life that we take for granted.
Representative Taggart.
Thank you, Madam Speaker. I have had the opportunity to work with this community quite a bit these last couple of years. And every time I think about them, it is extremely emotional. And it reminds me how lucky we are when our children are totally healthy. And so I'll read on to this. This year, people with IDD and those who support them are worried about how the state budget discussions might affect their services. The vast majority of services for people with IDD are provided through governmental programs, including Medicaid. The General Assembly, and I know ourselves, are committed to protecting services for this population to the maximum extent possible and ensuring funding is adequate to maintain the workforce of dedicated direct support professionals who deliver them and their parents. As policymakers, we must work with the IDD community to resolve the barriers they face and ensure an adequate workforce to meet the needs of Coloradans with IDD. We express our most sincere appreciation to people with IDD and the contributions they bring to our communities and to our state as a whole, and to the organizations and professionals, families, and individuals who provide services, advocacy, education, and support to people that desperately need their help. This day is important, and I hope important to all of us. Thank you.
Thank you, members. Representative Gonzalez.
Thank you, Madam Speaker. I wanted to highlight some of the people who are here on behalf of IDD Advocacy Day. So I have some people from Greeley. I also want to recognize somebody who's part of the IDD, who's an advocate for that. Her name is Tia. So during Black History Month, when we ran the resolution and I talked about Tony, Tia is actually the sister of Tony. So could you please stand up and be recognized?
Representative Hartsook.
Thank you, Mr. Speaker Pro Tem. I was stalling here, hoping that my folks could show up. But today is Parker Day at the Capitol. We have the mayor, Josh Rivero, and the entire town council with him. And we also have the Parker Chamber with TJ Sullivan as the president and CEO and the whole chamber. And what we did a couple years ago, we passed the Parker Wine Walks, which ended up, that legislation benefited every small community across the state. It gave them some additional work for the small businesses and income, and that was very grateful for all of them. They loved all of that. So thank you. If you see them walking around, welcome them. Thank you.
Thank you. Further announcements? All right. Thank you all. I think she'll be right back. Majority Leader Duran.
Thank you, Mr. Speaker Pro Tem. I move to proceed out of order for consideration of resolutions.
Seeing no objection, we will proceed out of order for consideration of resolutions. Majority Leader Duran.
Thank you, Mr. Speaker Pro Tem. I move for the immediate consideration of Senate Joint Resolution 13.
Seeing no objection, we will proceed to the immediate consideration of Senate Joint Resolution 13. Mr. Schiebel, please read the title of the resolution.
Senate Joint Resolution 13 by Senator Simpson, also Representative Stewart Kay, concerning the recognition of Youth Mental Health Action Day.
Representative Stewart.
Thank you, Mr. Speaker Pro Tem. I move Senate Joint Resolution 13.
Tell us about your resolution.
Thank you, Mr. Speaker Pro Tem. So last week on February 26th, we celebrated Youth Mental Health Practitioner Day. And today, we are hearing this resolution in the chamber. Pediatric healthcare providers play a vital role in identifying, supporting, and treating the mental health needs of children and youth across Colorado. On February 26th, Youth Mental Health Action Day, we honor the tireless efforts of pediatric healthcare providers and commit to collaboratively supporting Colorado's kids' mental health and well-being. 62 out of 64 counties in Colorado are mental health deserts, and the folks that suffer the most are our youth. So I really encourage that we utilize every tool in the toolkit to ensure that our kids grow up healthy and strong mentally and physically, and ask for an aye vote on this resolution. Thank you.
Seeing no further discussion, the motion before us is the adoption of Senate Joint Resolution 13. Mr. Schiebel, please open the machine and members proceed to vote. Representative Flanell, how do you vote? Representative Flanell will come back to you. Representative Bradley, how do you vote?
Yes.
Representative Bradley votes yes. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Flanell, how do you vote?
Yes.
Representative Flanell votes yes. Representative Carter. Representative Carter, that'll be a $5 fine. Please close the machine. With 62 ayes, 0 no, and 3 excused, Senate Joint Resolution 13 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Madam Majority Leader.
Thank you, Madam Speaker. I move to proceed out of order for third reading.
Seeing no objection, we will proceed out of order for third reading. Mr. Schiebel, please read the title to House Bill 1189.
House Bill 1189 by Representative Espinoza, also Senator Snyder, concerning property held by a community property spouse subject to the Uniform Community Property Disposition at Death Act.
Madam Majority Leader.
Madam Speaker, I move House Bill 1189 on third reading and final passage.
The motion before us is the adoption of House Bill 1189 on third reading and final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Slaw, how do you vote? Oops. Representative Slaw, you are on mute.
Thank you, Madam Speaker.
Representative Slaw, how do you vote?
No.
No. Representative Slaw votes no. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Flanell, how do you vote?
Yes.
Representative Flanell votes yes. Representative Bradley is excused. Please close the machine. With 61 aye, 1 no, and 3 excused, House Bill 1189 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1039.
House Bill 1039 by Representatives Carter and Ricks, also Senators Judah and Weissman, concerning requirements for municipal jails.
Madam Majority Leader.
Madam Speaker, I move House Bill 1039 on third reading and final passage.
The motion before us is the adoption of House Bill 1039 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Flanell, how do you vote?
No.
Representative Flanell votes no. Representative Slaw, how do you vote?
No.
Representative Slaw votes no. Please close the machine. With 46 ayes, 16 no, and 3 excused, House Bill 1039 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1044.
House Bill 1044 by Representatives English and Joseph, also Senator Exum, concerning measures to improve equity in maternal health.
Madam Majority Leader.
Madam Speaker, I move House Bill 1044 on third reading and final passage.
The motion before us is the adoption of House Bill 1044 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Flanell, how do you vote?
No.
Representative Flanell votes no. Representative Slaw, how do you vote?
No.
Representative Slaw votes no. Please close the machine. With 49 aye, 13 no, and 3 excused, House Bill 1044 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1135.
House Bill 1135 by Representatives English and Joseph, also Senators Benavidez and Marchman, concerning increased transparency regarding chemicals used in the processing of certain hair products.
Madam Majority Leader.
Madam Speaker, I move House Bill 1135 on third reading and final passage.
The motion before us is the adoption of House Bill 1135 on third reading, final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Slaw, how do you vote?
No.
Representative Slaw votes no. Representative Flanell, how do you vote?
No.
Representative Flanell votes no. Please close the machine. With 42 aye, 20 no, and 3 excused, House Bill 1135 is adopted. Co-sponsors. Please close the machine. We have not closed yet. Representative Lindsay, co-sponsors. Mr. Schiebel, please read the title to House Bill 1134.
House Bill 1134 by Representatives Mabry and Velasco, also Senators Amabile and Weissman, concerning measures to ensure that municipal court defendants are subject to conditions similar to state court defendants.
Madam Majority Leader.
Madam Speaker, I move House Bill 1134 on third reading and final passage.
The motion before us is the adoption of House Bill 1134 on third reading and final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Slaw, how do you vote?
No.
Representative Slaw votes no. Representative Flanell, how do you vote?
Yes.
Representative Flanell votes yes. Please close the machine. With 43 aye, 19 no, and 3 excused, House Bill 1134 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1113.
House Bill 1113 by Representatives Sirota and Wilford, also Senators Wallace and Weissman, concerning modifications to laws regarding elections.
Madam Majority Leader.
Madam Speaker, I move House Bill 1113 on third reading and final passage.
The motion before us is the adoption of House Bill 1113 on third reading and final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Slaw, how do you vote?
No.
Representative Slaw votes no. Representative Flanell, how do you vote? Representative Flanell, I believe you're on mute.
Sorry, no.
Representative Flanell votes no. Representative Bradley, how do you vote?
No.
Representative Bradley votes no. Please close the machine. With 41 aye, 22 no, and 2 excused, House Bill 1113 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Madam Majority Leader. Oh, one announcement before we proceed. Representatives Brown, Sirota, and Taggart are excused at such time as necessary for the Joint Budget Committee meeting. Madam Majority Leader.
Thank you, Madam Speaker. I move for House Bill 1095 to be removed from the special orders calendar and placed back on the general orders second reading calendar.
Seeing no objection, House Bill 1095 will be removed from special orders and returned to general orders. Madam Majority Leader.
Thank you, Madam Speaker. I move that the following bills be made special orders on March 3rd, 2026 at 9:47 a.m. House Bill 1110, House Bill 1026, and House Bill 1002.
Seeing no objection, the bills listed by the Majority Leader will be made special orders today at 9:47 a.m. Representative Lukens. Members, you've heard the motion. Seeing no objection, Representative Lukens will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen on iLegislate and in today's folder on your box account. Bills will be laid over upon motion of the Majority Leader, and the coat rule is relaxed. Mr. Schiebel, please read the title of House Bill 1110.
House Bill 1110 by Representatives Camacho and Jackson, also Senators Catlin and Danielson, concerning the protection of vulnerable adults from financial exploitation in relation to financial institutions.
Representative Camacho. Representative Camacho.
Thank you, Madam Chair. I move House Bill 26110 and the committee report.
To the finance report, Rep. Camacho.
Thank you, Madam Chair. In the Finance Committee, we considered robust debate on numerous issues, and we asked for a yes vote.
Is there any further discussion? Seeing none, the question before us is the passage of the finance report. All those in favor say aye. Those opposed, no. The ayes have it. The finance report passes. To the bill, Representative Camacho.
Thank you, Madam Chair and committee members. Colorado has to face the fact that financial scams and exploitation are becoming more and more commonplace, sophisticated, hard to spot, and difficult to resolve. While everyone is at risk of financial exploitation, our older adults are not only the most targeted, but historically, financially vulnerable groups. We're not talking about a small dollar loss. The FBI estimates that $3.4 billion was stolen from older adults nationally in 2023 alone. Our older adult population is already stretched thin between health care and Medicaid costs, rent, insurance, and general rising costs. House Bill 261110 safeguards the money of older adults from individuals looking to exploit this vulnerable community, providing qualified individuals in banks and credit unions with the discretion to place holds on disbursements that they have good reason to believe may be instances of financial exploitation. The ways in which financial exploitation occurs can cause great distress to older adults. Individuals engaging in financial exploitation use deception, harassment, intimidation, or undue influence to deprive victims of something of value to them. There are documented psychological impacts of financial exploitation of affected individuals, a catastrophic consequence on a community that already deals with pervasive loneliness, medical issues, and a lack of financial security, among other difficulties. Eligible adults under this bill are defined as 70 years or older, and individuals 18 years or older who are unable to perform or obtain services necessary for health, safety, welfare, or lack of sufficient understanding and capacity to make or communicate reasonable decisions. If a qualified individual reasonably believes a disbursement or attempted disbursement may be exploitative, they may place a hold on the disbursement from the eligible adult. Then they have 90 days beginning on the date of the delay to make a determination. If investigation was opened by local law enforcement or adult protective service county agencies, then they have 180 days to make a determination from the date of the hold. The bill also takes transparency into account, requiring qualified individuals and institutions to provide access to or copies of records relevant to suspected or attempted financial exploitation to eligible adults. Colleagues, during the stakeholding of this bill, it was pretty clear that everyone who has an interest in someone in their community who's an older adult has been impacted by fraud. It was pretty clear that everyone has very personal stories of loved ones and neighbors and family members who have lost everything to financial fraud. And what this bill is attempting to do is get in line with many other states that have provided this type of protection to protect those vulnerable older adults from this exact happening. We're not saying you don't have a right to your money. We're saying that when a financial institution sees instances of fraud, it's good to take a beat. It's good to take a moment just to make sure, because the consequences are irreversible and devastating for our friends, neighbors, and older adults.
Rep. Jackson.
Thank you, Madam Chair. This bill is intended to prevent elder financial abuse by giving liability protections to staff at the financial institutions, specifically banks and credit unions, by allowing relevant personnel to place temporary holds on suspicious transactions. If we take that liability away, then financial institutions are not going to be as willing to put holds on these transactions. And I think the level of exploitation and fraud will increase if people are scared to look into what's going on with these transactions. So I would ask for a yes vote on this bill. Thank you for your support.
Rep. Gonzalez.
Thank you, Madam Chair. So I want to commend the sponsors for this work on this bill. Speaking as an ex-banker in the financial services industry, I can tell you that elder fraud is prevalent. We have some systems in place that while they do help mitigate some of that risk, it does not mitigate the risk 100%. We can argue that the risk can never be mitigated to zero, but I think one of the things that we should understand is this legislation was heavily stakeholdered with no registered opposition. It has brought together Colorado's financial institutions, which include the credit unions, the banks, and advocacy organizations working with older adults, including AARP, Colorado Center for Aging, Colorado Alzheimer's Association, diverse supportive groups, and also include Colorado District Attorney's Council, Violence Free Colorado, Disability Law Colorado, the Office of Financial Empowerment within the Attorney General's Office, and the Bell Policy Center. So of course you're asking why this bill. Some of the arguments when I sat in the Finance Committee was that, well, we should probably have Congress take action on the specific issue. And as we all know, when we in this body that we have said that we're blaming the federal administration and Congress for our current situation we face ourselves in Colorado, why would we want to give Congress more authority, let alone wait for Congress to act? We know Congress does little when they're in session. As you know, little stuff gets passed. So I think this is something that we should take it upon ourselves it's at the state of Colorado to make sure we protect our vulnerable adults from fraud. And so crime is on the rise, especially financial fraud, internet fraud, things with the digital age. We're facing more exposure to risk, especially our senior citizens. And I can tell you from experience, there's usually those cues that we look for in the banks. And the banks, at least speaking from as an ex-banker perspective, we have trainings and policies in place to help mitigate that. again, we have continuously robust training and, education, especially when it comes to this issue. Unfortunately, it does not go far enough because the banks are also limited by certain policies that we have, whether it's state or federal. And so I think that this bill would go the extra mile to make sure that we help mitigate and protect our senior citizens who not only suffer from elder abuse, but also fraud. And so when it comes down to the financial services industry, it all comes down to one word, and that's risk. And how do we mitigate the risk? Because at the end of the day, I would have to have tough conversations with some people who I believe were in danger of having risk, whether it's fraud, whether it's wiring money or whether it's sending money or giving money to somebody, pulling out large amounts of cash, asking these tough questions. Sometimes you would face pushback from these people, but at the end of the day, I would rather make sure I keep, the customer at the center of what I do, because I would rather have them yell at me saying, no, why are you asking all these questions? Instead of them coming back and say, why didn't you do anything to stop it or help me? Why weren't you curious enough to know what this was for? Why weren't you asking the questions that you should have been asking? So at the end of the day, there was trade-offs. These are tough conversations, but I think this is a good bill to get us at least in a better position to help mitigate these people that we know, that we all know, or we have heard from that have been impacted by the fraud and abuse.
Rep. Garcia.
Thank you, Madam Chair. Members, I applaud the intention of this bill. The execution of this bill, however, causes more harm than it does protections. When we are claiming that banks and credit unions are teaming up with AARP to increase protections for the elderly and other vulnerable populations, while in the same breath completely eliminating any sort of liability on the financial institution for any fraud, that is not protection. That eliminates a tool of protection for those that are taken advantage of. In committee, we asked many, many questions to the sponsors. We asked many questions to the witnesses. We were told, we were promised on the mic that we would be able to work through these concerns with the sponsors, and yet here we are right now without any effort of trying to get to a place where we could say that, yes, this is a good bill. Should this bill pass, this will create more harm. We all want to protect the vulnerable. We all want to protect the elderly from continuing to be targeted by financial scheming. But on page 8, lines 7 through 12, completely negates the protection. And with that, Madam Chair, I move L007 and ask that it be displayed.
One moment. L7 is properly displayed. Rep. Garcia.
Thank you, Madam Chair. Members, I don't want to be up here bringing a hostile amendment. I would have loved to actually have gone through the process that was committed to in committee to work through these problems. I would have appreciated the courtesy of our sponsors to work with us on these concerns that we laid out very, very clearly in committee about the harms that this bill can cause. That did not happen. So now, yes, I am bringing this amendment. What this amendment does is it strikes the section of the bill that removes liability from the financial institutions. By doing so, we are still offering the elderly and other vulnerable populations listed in the bill a legal recourse when they are experiencing fraud, when the money has been delivered when it shouldn't. Financial institutions take on a certain level of responsibility and liability when they engage in this practice. When they decide to be the holder of everyone's money, when they decide to be the conduit of transferring funds here and there, they take on the responsibility and the liability. And what we are doing right now with this bill, should we not accept this amendment, is we are saying, except you know what, you don't actually have to have that liability anymore. you are going to be scot-free. Go ahead and do what you do. The elderly, vulnerable populations, they don't need a legal recourse. Go ahead and make that transfer and earn your $3 transfer fee. Members, I ask for an aye vote.
Rep Camacho.
Go ahead,
Rep Tatone.
I rise. Thank you, Madam Chair. I also rise in support of this amendment. In the committee, we had a very robust discussion, and we asked a lot of questions. We wanted to get to the answers, and there was willingness to have a discussion after the committee to come up with some solutions, and that did not happen. We did not get any of that courtesy. So that is something that is very concerning to me. This particular part of blanket immunity is also a part that gives me a lot of consternation. This is like the disguise of having AARP, of saying this is a great bill, and then having this in there. I mean, we've got attorneys here who know a lot about this kind of thing. We cannot have blanket liability in this bill. I ask for a yes vote on this amendment to take that part out. Keep the other part in. That is a good safeguard, but the blanket immunity has to go. I ask for a yes vote on the amendment.
Rep Camacho.
Thank you, Madam Chair. I think there is a critical distinction between working with someone and disagreeing with someone. If we disagree with your approach, it doesn't mean we didn't work with you. It means we disagree with your approach. This bill already provides the protection necessary. This bill provides protection for our seniors. And as an attorney, I've also read this, and I understand it too. This bill is good for our community. This bill puts us in line. With this amendment, it does harm. We ask for a no vote.
Rep Jackson.
Thank you, Madam Chair. And I also just want the record to reflect that we did have conversations yesterday about the amendments, about this bill. And so to say that didn't occur, I'm not sure where that's coming from. Thank you.
Rep Woodrow.
Thank you, Madam Chair. It is an honor to serve with you.
And an honor to serve with you.
Members, I rise in support of Amendment L007. We heard this bill in the Finance Committee, and I can tell you the witness testimony was exceptionally impactful. No one in this chamber would doubt that the elderly are susceptible to fraud and abuse from those who seek to take advantage of them. Today's modern fraud occurs mostly electronically via phone calls, phishing scams, text message scams, and other nefarious plots to separate elderly folks from their hard-earned savings. We all agree on that. And I would very much like to support this bill. I was a yes in committee with the understanding that we would continue to work on one issue and one issue only, and that is immunity for banks, credit unions, and other financial institutions when they fail to follow what the bill sets out. Under the terms of the bill, as written, a bank or financial institution must provide notice or delay the processing of a transaction that they know or have reason to know is fraudulent. And if you don't provide the notice, or if you fail to delay, for some reason, the bill as written provides the bank, the credit union, or financial institution with immunity. What this amendment does, by striking lines 7 through 12 on page 8, is it removes that immunity provision. Most of the bill is about immunity. There's a disclosure provision that has immunity in it. There's other provisions that have immunity in it. There's an immunity provision where if you do delay the transaction, and I think that's fair, if the bank errs on the side of caution and doesn't release the funds over a customer's ardent protest because the bank knows it's fraud, then the bank shouldn't be sued for delaying the transaction. But that's not what the language on page 8, lines 7 through 12 does. It does the opposite for this narrow set of circumstances where the bank knows or has reasons to know that the transaction is fraudulent. yet still processes the transaction anyway. That means that the elderly person is now their funds are gone. The bank processed the transaction knowing it, or should have knowing that it was fraudulent, and now that elderly individual has no recourse against the bank. The bank is held civilly immune instead of civilly liable. I believe that this provision is in response to several lawsuits over the past few years, including one from the CFPB, seeking to hold banks accountable when they process these very types of transactions, knowing that they should not. We tried to work with the bill sponsors. I don't think that the amount of time that we've had has been sufficient. We obviously are here. It is obviously seconds. I wish we had more time to discuss it with them. We even have a stakeholder meeting set up for tomorrow of all days to discuss this further with AARP, with the Bell, and other organizations that have been working on this. I would urge an aye vote.
Rep. Camacho.
Thank you, colleagues, and I respect greatly my colleague from Denver. As attorneys, sometimes we read things differently, and I will point to you in the bill where our interpretations diverge. In the bill, it says, in good faith. If you have a good faith belief to pause one of these transactions, you are not liable. If you know it is fraud, that is not good faith. This bill does not cover that. This amendment is not necessary because this bill already accounts for that situation. We ask for no vote.
Rep. Hamrick.
Thank you, Madam Chair. This amendment would remove liability protections for financial institutions that are acting in good faith. That would effectively stop every financial institution from ever placing a hold to stop fraud. I ask for a no vote on this amendment.
Rep. Garcia.
Thank you, Madam Chair. There's a couple things I want to clear up as it relates to this bill and interpretations. For all the rest of you in this room that are also not attorneys, that does not mean you don't know how to read law. Just know that. In this particular case, it is important to consider, why do banks want this bill? They can already do this. They can already step in, intervene, and hold funds. So then why is this needed? It's needed because of page 8, line 7 through 12. They can already hold funds when they are detecting fraud. We heard in committee that it happened over and over and over again, and people were grateful that it happened. So why then do we need this bill? If not to give blanket immunity to financial institutions, and that is not protection, ladies and gentlemen. That is not protection. This bill will not protect the elderly and the vulnerable should it pass as written. We must accept this amendment. We must adopt this amendment so that way the intention, the good intention of the sponsors is made true. That the elderly and the vulnerable are in fact protected. I urge and I vote.
Rep. Woodrow.
Thank you, Madam Chair. I appreciate as well my colleague from Denver. Good faith is not defined in the bill. What if a customer is adamant? No, process this transaction. I know what I'm talking about. Get it done. This is for my nephew in Taiwan. He needs the money right now. This is for my loved one. It's for my new boyfriend. He tells me he loves me. Process the transaction immediately. Stop holding up my funds. I'll sue you. When an elderly person is being taken advantage of, it is not uncommon for tellers and bank officials to hear these very types of pleas. And nothing in the bill makes clear that that's not good faith. A bank teller being harangued by a customer, being pressured by a customer, hitting yes on the transaction could very well be interpreted as good faith, even though the bank's internal fraud detection system, which, by the way, we heard a litany of testimony on, is beyond our own understanding of just how sophisticated these systems are. They know when something is fraudulent, right? So if they go ahead and they process the transaction and claim, well, the customer was haranguing me, we did it in good faith. And now the customer is going to have no recourse even though the bank knew or should have known better. I ask for an aye vote.
Rep. Bottoms.
Thank you, Chair. I actually have a very real story about this that I think is pretty pertinent. 5 years ago, my father already had dementia, pretty good dementia, and he got a pop-up on his computer that said something about, would you like $500? So he clicks on this, and there is immediately somebody comes online with him and starts to ask him about his finances. Now, he has dementia. At that time, he's 75 years old. We knew he had dementia. We were working with him. We were in the process of building a trust and also getting power of attorney for him, complete power of attorney, including everything medical, financial, everything. He banked with USAA at the time, which is also who I banked with. And we were going through his we had access to all of his money, and we were going through his finances, and he had been told by this person online that if he would send $50,000 to Thailand, that he would get all of that money back plus $500. Now, most people would recognize this is not good. This is not good. But he did have dementia. He did have some cognitive stuff going on. He actually had dementia and Alzheimer's at the same time. And so he does this thing, starts transferring the money. My wife happened to be online at the moment, which is the only way we caught this. She was online looking at his bank account, and all of a sudden, $50,000 gone. So she immediately goes and calls USAA. Actually, I call USAA and start talking to them about this. I got the lady at the bank that takes care of the transactions. There's a handful. She actually was the one transferring the money as I called. And I began to talk to her about this, and she said, yes, my father did the same thing about 3 weeks ago. She said, would you like me to stop this transaction? And I said, yes, I would. She said, do you have power of attorney? I said, I don't have power of attorney yet, but it's in the process. The lawyers are finishing it up right now. She said, you are on his account, though. I said, I'm on account, got all that. The $50,000 had already left the bank. She stops it somehow after it left the bank and pulled the $50,000 back into my father's account. My father had already talked to her and had been convincing, and I think this is what Representative Woodrow was just trying to verbalize. He was saying, this is my money, I can do what I want to it, and she was trying to get him to not do this. But that is not the bank's responsibility. It never has been the bank's responsibility, it never will. And my father almost lost $50,000 in that moment, but that's not the bank's responsibility. They are going by law that says, even though, yes, he has dementia, she doesn't know that. Yes, he has Alzheimer's, she doesn't know that. And he is saying, I want you to transfer this money. And she's saying, are you sure? Do you know anyone in Thailand? He says, I want you to transfer this money. The bank was doing what they are responsible for doing. Somehow adding laws in and then somehow saying we need to bring this down. I've heard we want to bring it down all the way to 50 years old so that anybody 50 and above can say to the bank, well, you're now responsible for bad decisions. I'm in this space. I know what that is. That was a horrible decision of my father's. It was dementia-led. It was manipulation by people in Thailand. But the bank had not manipulated him, and the bank should not be responsible for that. They are trying to do the best they can for everybody, and to add some kind of laws on top of this, I think it's horrible to the banks to try to make the banks responsible for this kind of transaction. And by the way, this isn't just one or two older people that this is happening to. And so how are they supposed to catch this? How are they supposed to catch this by the thousands, by the 10,000s, when there are some very bad actors? Now, my heart was I wanted to catch this guy that had done this in Thailand in a back room, and I would take care of all of this. But that's not the bank. That's not the bank's fault. We cannot penalize the banks for doing what they are supposed to be doing, even though sometimes it includes people being taken advantage of. We can't make the banks be on the hook for this. They are truly innocent in the process. They're not the bad guys, and they're not the ones that are allowing or asking the funds to be transferred. We can't penalize the middleman that is the arbiter for this financial transaction. And I really don't understand, I truly don't understand societally why we want to put somebody on the hook that is not responsible. We just arbitrarily say, hey, look, you're going to pay for the mistakes. This was my father's mistake. Why should the bank pay for it? This is Thailand being manipulative, being evil, in my opinion. Why do we make the bank pay for it? Why do we put the bank on? Because somebody has to take responsibility. Somebody has to pay somebody else's responsible debt. That is not okay, and that is what is continuing to collapse us as a society and collapse us financially and collapse us across the board. You cannot continue to charge people these things that are not their responsibility and expect our society to continue to move forward. Who else is going to be responsible? The phone company because you used a phone call? The internet company because you used the internet? Who is everyone else on the list that's going to have to pay for my father's mistake? Yes, he had dementia, but it was my father's issue. Who are we going to line up to make sure they pay for his mistake? This is not okay. This is not what our country or our banking or our economic systems are based upon. But we have such a disease in our country right now, and specifically in this state and specifically in this building. Somebody else is going to pay. Somebody's going to pay. That has got to stop.
Rep. Mabry.
Thank you, Madam Chair. Members, I support this amendment for a few reasons. One, our colleague from House District 2 mentioned, the chair of the Finance Committee mentioned that this language can be interpreted as a liability shield for existing law, right? Actions by the CFPB have been brought against banks on failures to delay disbursement already. And so I also just want to recognize that the bill sponsor said that this amendment will do harm. I do not understand how making this bill a little more consumer friendly does any harm. Respectfully, I do not know how taking out a liability shield for banks is bad for the people that we're trying to protect, because I support the goals of this legislation. I also just want to note that businesses already have a legal standard that assumes if they're operating in good faith, then liability isn't necessarily going to be applied. That's already an argument that businesses can bring up in lawsuits. And so just adding that language here, you know, it's something that we can point to, but courts already put good faith standards on businesses in cases like this. And so I want to be clear, I support the goals of the bill, I support the legislation, but it makes no sense to me in a bill that is about protecting seniors from fraud that we put a liability shield in here against banks that I believe there is a good faith interpretation goes beyond the scope of the protections that we're trying to create in this bill. We shouldn't be doing that. We should be making sure that we're doing everything in our power to protect our seniors, and I appreciate the stakeholding on this bill was thorough, and probably this language came from some stakeholding. Well, again, the finance chair reminded us that there have already been actions under existing law without these new protections meant to protect seniors from incidents like this. And this language that we're trying to strip out could be interpreted to prevent those actions. And so I worry if the bill passes with this language in it that it actually limits the ability of consumers to protect themselves. And so I support the bill, but I believe this language should be removed.
Rep. Bottoms.
Thank you, Chair. While I was loquacious earlier, maybe not clear, I don't like this amendment.
Is there any further discussion? Seeing none, the question before us is the passage of L7. All those in favor say aye. Aye. Those opposed, no. No. The noes have it. L7 is lost. Is there any further discussion on House Bill 1110? Rep. Woodrow.
Thank you, Madam Chair. I move L008 and ask that it be properly displayed.
One moment. L8 is properly displayed. Rep. Woodrow.
Thank you, Madam Chair. All right, colleagues, so L007 had struck the entirety of the immunity section on page 8. This amendment, L008, does something a little more narrow and focused. There are two immunity pieces here. The first is if the bank fails to provide notice, and the second piece is if they fail to delay the disbursement. I'm okay if the bank in good faith fails to provide the required notice. Mistakes happen. It's generally no harm, no foul in that sense. A lot of these notices end up being perfunctory in the end. Folks don't always read them. Raise your hand in this room if you read every notice that you get from your bank. Exactly. So what I am okay, what L008 does is it limits what we're striking out of the bill to just the failure to delay the disbursement. Again, in Rep. Bottoms' example, let's say that transaction had been processed by the bank and he could have proven that the bank knew or should have known that the transaction was fraudulent and should not have happened, yet the $50,000 went out the door anyways, they'd be without recourse. And we can talk about, traveling overseas and seeing people face to face, but at the end of the day, if the bank knew it was fraudulent, it shouldn't have processed the transaction. And so what L008 does is it more narrowly focuses what we're taking out of the bill. We are taking out the piece that provides the bank immunity when they fail to delay the disbursement. Not wholly stop sending the funds forever, but if they fail to delay, to give enough time for the person's family, which is contemplated in the bill itself, to come and explain, hey, this transaction is fraudulent, do not process it. If the bank ignores that and processes the transaction anyways, we don't want the elderly person to be without recourse. Yes, it is important for people to take responsibility for their finances. We are talking about elderly folks who lack the capacity to do so. I urge an aye vote on L008.
Rep. Garcia.
Thank you, Madam Chair. Members, thank you for engaging on the other amendment. Womp womp. Now we're back trying this one. I think this is a great compromise. If the sponsors insist on removing liability for financial institutions in certain circumstances, it should definitely not be in this circumstance. I again don't want to say that the intention of the sponsors is ill or that they don't truly want to protect the elderly. I think we need to understand that the impact of our votes have a real, true impact on the people. And if we don't ensure that the banks and financial institutions maintain some form of liability, particularly in this instance, we are, in effect, leaving the elderly and the vulnerable out to dry. They will no longer have financial recourse. I want to say again, I wish that we did not have to be coming here presenting these amendments in this way. I wish that the commitment to have at least engaged with us and worked with us on these concerns had been followed through with. But it wasn't. So this is why we're here right now. We want to get this bill to a place that when all of us are able to vote yes on this, we are not going to be detrimentally impacting the community that's intended to support and protect. Please vote yes.
The committee will go into a brief recess. The committee will come back to order. Rep. Woodrow.
Thank you, Madam Chair. I withdraw L008.
L8 has been withdrawn. Rep. Zokai.
Thank you, Madam Chair. I move L009 to House Bill 1110 and ask that it be displayed.
One moment. Rep. Zokai.
Thank you, Madam Chair. This amendment is addressing a concern that you have heard outlined today. We want to ensure that our vulnerable populations are safe from financial fraud and ensure that if a bank or a credit union were to process a transaction that they known or should have known is financial exploitation, that there is some liability, so that if somebody is in the situation where they are losing their savings, they do have some recourse to be able to recoup that loss. As our sponsors have stated, this is, as they interpret the good faith exception to be in the bill, and so we are outlining exactly what it means to operate in good faith. And we want to thank the sponsors for working with us on this language.
Rep. Woodrow.
Thank you, Madam Chair. Colleagues, this is a good amendment. I want to thank the bill sponsors for working with us this morning in a pressure cooker situation to get this done. They have graciously informed us that this is an okay amendment, and we ask for an aye vote. Thank you for working with us.
Rep. Garcia.
Thank you, Madam Chair. I also want to just express my gratitude to the sponsors for engaging in the conversation today and working with us until we got to an amendment that we all agree with. Thank you.
Rep. Jackson.
Thank you, Madam Chair, and I would ask for a yes vote on this amendment. None of us want to have anyone be financially exploited, and we can all agree that it is not acting in good faith if someone knowingly allows a fraudulent transaction to go through. So I support this amendment. Thank you.
Rep. Bottoms.
Thank you, Chair. Going back to the story of my father, when I was talking to the bank and explaining the situation to the bank, that made sure that they were in the category that the first part of this amendment says, which is that they knew. I struggle with this, or should have known. Who makes that decision? Who decides should have known? How do we define should have known? The should have is very ambiguous here and still puts a huge liability on the bank for something that the bank may not have any clue about, but someone else decides they should have known. Now, in my father's example, they did know. I was talking to them on the phone. But if I would not have called them, how should they have known? He was telling them, send the money to my best friend in Thailand. How are they supposed to should have known? This is still not okay language when you include the should have known. The known, no doubt about it. I don't have a problem at all for banks. If they would have sent that money anyway while I was talking to them or didn't try to stop it, yes, we would have held that bank liable for that $50,000. I'm totally comfortable with that. But should have, guys, we put this kind of language in bills way too often. Who's the arbiter of should have? Who gets to make that decision? That makes no sense to me, and I think this amendment seems to be the exact same thing as the other two amendments that are coming through. I don't know what conversation was had in the back room. I don't know how they got other people to agree on this or make this agreement, but the should have is totally out of line here and does the same thing as all of these other amendments that have come through. My suggestion is bill sponsors, hold strong and do not cave on this. This is not a good amendment. This is not a good amendment, and I don't know how they convinced you, but this is not a good amendment. I stand with the original bill with the sponsors put up originally. Please don't cave to whatever happened back there.
Rep. DeGraff.
Thank you, Chair.
Words mean things. So I thought, well, I'll just look up good faith. Not only that, but the legal definition of good faith. So I think I have it here. So good faith is honesty or sincerity of intention. The details contained in this brochure have been published in good faith, honesty or sincerity of intention. And so here we could read that, and we could say a financial institution or a qualified individual that in honesty or sincerity of intention fails to provide notice pursuant to this section. So then it links it back. So instead of using the cumbersome language, we just have, instead of saying honesty or sincerity of intention, we just say in good faith. Now, of course, somebody would have to fight, that would be an upward consideration, right? They would have to prove that they were not in good faith. But now we come to this one over here, and I think it is problematic. If they have known, well, if they had known it was bad, then they were not acting in good faith, and you could show that they were not acting in good faith. They were not acting honestly or with sincerity of intention. Because I thought, one of the things I didn't know going into this was the relationship of the bank. And the bank does not have, they have a contractual relationship with you, but they don't have a fiduciary relationship with you. If they had a fiduciary relationship with you, they probably would not charge you the rates that they charge you. But we go down that path and we say we want this contract. Now, there's another option out of this, and that is common. And that is to have somebody declared incompetent so that they are not making these decisions. But until somebody so if a family makes a decision that a loved one is not able to make these decisions on their own, that is something that can be adjudicated. But until that point, they are free to make those decisions on their own. But that is something that, that's a familiar thing. That's something that goes on inside of families. That's something that goes on. Now, I do understand with the fractured nature of society now that sometimes we don't have that. But there are other processes for that. But this here, I think that, what is should have known? How should they know it? If they had known, they were not acting in good faith, so I don't know how that changes it in a sense, but now you say they should have known it. And that is that they should have known. That knowledge is out there. It's not questioning whether they did it in good faith. It's not whether they did it in honesty or sincerity, like they honestly believed that was not a contractual violation, but or sincerely believed that it was the intentions of that individual. But until that individual, the bank, the financial institution has to approach this and say that individual has the capacity and the agency to make that decision. So now I'm not really sure, because this starts to get into an area where you start to just remove that agency from people and put that on put that on the institution, that they should have known better on behalf of the individual. So I get it. The good faith it's not that good faith is not defined. Good faith has a definition. Good faith has a common usage. And I think good faith was the right move here. So I think it's general enough. It puts the financial institution in a position where they are required to act honestly and sincerely. Not a fiduciary at this point, because that's a whole nother relationship, but that this agency is not being taken from them. So I get the intent, but I think the intent is to put this onto banks and financial institutions where it was not before. So the idea here was to give them the leeway, when my read of this, that the financial institution or qualified individual that in good faith fails to provide notice or fails to delay a disbursement. So this section specifically is in relation to if they fail to make a disbursement. So if you go in and you demand that they make a disbursement, Right now, they have a contractual obligation to make that disbursement. So this section gives them the out to say that, hey, we sincerely thought that this was fraud. We honestly thought that this was in your best interest to delay this transaction that we are contractually obligated to perform. And so this, right now, the language gives them an out from fulfilling a transaction that they're otherwise contractually required to perform. Now this comes up here, puts it right back on them and say, well, you should have known if you do make the transaction. So if they don't know, so I get the intent, but I think this is doing some hello.
Hello.
It's happening again. It's happening again. So my colleague clearly would like to speak to this amendment. I'm okay with the intent in good faith. I'm sure this amendment was promoted in good faith, but we don't know what that means. But I think they honestly or sincerely, I should have known that it was presented in good faith, and that's all that should matter about the law. So my colleague who's Garciaing me will now explain.
Rep. Zokai.
I take that as a compliment. Thank you, Madam Chair. Known or should have known is language that you do typically see in the law, so I understand there might be some confusion and happy to go over this amendment more, but I think we need a little more time to flesh it out. So for now, I am going to withdraw Amendment L009.
L9 has been withdrawn. Majority Leader Duran.
Thank you, Madam Chair. I move to lay over House Bill 1110 until tomorrow.
House Bill 1110 has been laid over until tomorrow. Mr. Schiebel, please read the title of House Bill 1026.
House Bill 1026 by Representatives Marshall and Hamrick, also Senator Kolker, concerning an expansion of plan options for the Public Employees Retirement Association.
Rep. Hamrick.
I move House Bill 1026.
To the bill.
Members, as you all know, PARA is the retirement system for many of Colorado's public employees, and PARA benefits are tied to service credit, the years you are working and contributing. House Bill 1026 is about making PARA fit the reality of today's workforce while protecting the integrity of the PARA funds. Many public employees don't have a perfectly straight, uninterrupted career. People may step out of the workforce or change jobs for reasons like caring for a child, an aging parent or a family member, a serious health issue, a spouse's job relocation or military moves, layoffs, budget cuts, or gaps between positions, returning to school or training, or other life events that temporarily pull them out of work. When that happens, it can reduce their service credit and ultimately reduce their retirement security. The goal here is clear: protect retirement security for employees with career gaps and expand retirement options without reducing existing benefits. First, it allows PARA members to purchase service credit for qualifying periods of unemployment, specifically periods when they were 21 years or older. That means if someone had a gap where they weren't employed, they can fill in some of the missing service credit by paying the cost so the retirement isn't permanently reduced just because of life events. Second, the bill expands access to supplemental retirement savings options by requiring PARA's voluntary investment program to offer both tax-deferred and Roth options, and requiring PARA-affiliated employers statewide to participate in and offer PARA's deferred compensation plan, also with pre-tax and Roth contribution options. There are guardrails. The bill is not a giveaway. It is structured with clear guardrails. Age limit for unemployment periods. A member cannot purchase service credit for time they were unemployed under the age of 21. You must already be a PARA member with service to purchase service credit. Members generally must already have at least 1 year of earned PARA service credit, and for certain categories, federal law treats differently. The threshold is 5 years. Documentation requirements: members must provide documentation like dates and records. No double dipping. The purchase cannot allow a person to receive retirement benefits for the same service under more than one plan. Caps still apply. Current limits still apply, including a cap that members who started on or before January 1999 may purchase no more than 5 years. Actuarially sound. PARA protected. The bill requires that the cost is sufficient to pay the actuarial liability associated with the purchase, meaning the member pays the full cost so it does not shift to the PARA trust. The service credit purchase is actuarially sound, protecting para. Why this matters. House Bill 261026 strengthens retirement security for people who served Colorado but had an imperfect career path. It also expands access to supplemental savings options statewide so workers have more tools to prepare for retirement. Members, this is a practical, fair bill with strong fiscal guardrails. I respectfully ask for a yes vote on House Bill 261026.
Rep. Marshall.
Thank you, Madam Chair. So, colleagues, I had a constituent bring me this concept, and my knee-jerk reaction was, oh, heck no, because I am very protective of para. Anything that might even slightly impact its long-term solvency or its actuarial soundness would be a no-go with me. But in good faith, I reached out to para and asked, and they said, no, we actually do not have a problem with this. It actually is a good concept, and we can set it up so it is actuarially sound and does not impact on para one bit. So it is an outstanding idea. Its time has come, and I hope you all can support it. Thank you.
Is there any? Representative DeGraff.
Thank you, Speaker. I get that, and I mean, para is a little bit different, and so I'll lay that idea aside. But I do want to go back to when we get into, so I'll ask that L001, sorry, we're on this one a little sooner than I thought, ask that it be properly displayed. I do. I want to move it. All right, I move L001 to H1026. And all that's doing is going to page 10.
Hold on one second, Rep. DeGraff. Okay, to the amendment.
Page 10, line 24, a little tricky here because it uncrosses may and crosses out shall. So this just puts a level of, you know, if this was a good idea, then it can be optional. But it doesn't have to be a shall because there might be some considerations that we don't know. So when you say each employer shall affiliate with a deferred compensation plan, I think maybe may affiliate is a better option. So just to get to keep the heavy hand of government out of contractual relations and say, hey, para, we've worked with para, we've done this, we think it's a good idea, and if it's a good idea, then optional. If it's truly a good idea, then optional is a good way to go. Just like in anything else, if a good intention is a good idea, it won't need a gun. When we start saying things that shall, you're looking at creating violations instead of options. And so I would like to move this out of the violation category, move it into the option category where it has to stand on its at least some level of exchange of good for good. And that's where the free market is superior, because the free market is always a voluntary exchange of one good for another good. Now this bill is offering a good, and if it is good for the employer, then that may will help make sure that this program remains good for the employer. If you make it shall, then the employer no longer has a reason, and then I think you're operating outside of the bounds of good faith of this. And we could go in and define good faith, but I think we could just act in good faith and say that if we honestly think that this is a good idea for employers, if we sincerely think it's a good idea for the employees, then we can move it into the voluntary transaction, the voluntary exchange of good for good, instead of the mandatory compulsory, and compulsory, where now you start to skew things and create a power imbalance that is that just doesn't work. Again, if a good intention is a good idea, it won't need a gun. Right now, this is in the compulsory. We want to move it into the voluntary.
Representative Marshall.
Thank you, Madam Chair. We're going to ask for a no on this amendment. It's an amendment worthy of discussion, but I am perplexed how it's just been dropped at this moment when we've been sitting down here in the well for the last hour and could have been given notification of this amendment. So there is certainly not enough time to digest what this does. The second issue, too, is, regardless of the good faith we were talked about, the second part is These are not just private contractual obligations. This is PARA, the Public Employee Retirement Association, with political subdivisions of the state. So the state is saying you will have to offer the public employees of this state the 401k Roth option. That's all it says. Thanks.
Representative DeGraff.
Thank you, Speaker. I'd just like to point out that the original language was may, and the bill moved it to shall. And so I thought the sponsors might know the reason for that and be able to speak to it since it was an intentional removal. So at some point in the law, it was still the public employee retirement account, and it was still optional by the original law, and now it is being made mandatory. So we are moving it in that direction, making it mandatory instead. So if it was okay before, then why does it have to be? Why does it become compulsory now when it was voluntary originally?
Rep. Marshall.
Hey, Madam Chair, we ask for a no.
Thank you, members. The question before us is the adoption of Amendment L001. All those in favor say aye. Aye. All those opposed, no. No. The amendment is lost. To the bill. Is there any further discussion on House Bill 1026? Seeing none, the question before us is the adoption of House Bill 1026. All those in favor say aye. All those opposed, no. The ayes have it. House Bill 1026 is adopted. Mr. Shebo, please read the title of House Bill 1002.
House Bill 1002 by Representatives Brown and Gilchrist, also Senators Ball and Pelton B, concerning measures to increase patient access to behavioral health providers and in connection therewith, efforts to enhance provider participation in healthcare provider networks, reimbursement of pre-licensed providers who provide mental health services under the supervision of a licensed provider, and decreasing the clinical hours required to become a licensed clinical social worker.
Representative Brown.
Thank you, Madam Chair. I move House Bill 1002 and the Health and Human Services Committee report.
To the committee report.
Thank you, Madam Chair. In the committee, we adopted a strike-below amendment that made significant changes, narrowed it to the commercial market.
One second, Representative Brown. I'm sorry. We'll go into a brief recess. Okay. I'm coming. We're back. Come back to order. Representative Brown.
Thank you, Madam Chair. So as I said, in the committee, we adopted a strike-below amendment that narrowed the scope of the bill, that limited it to the commercial market, that made important changes to some of the credentialing requirements that we had in the bill. And we have one additional amendment, and so I move L003 to House Bill 1002 and ask it to be properly displayed.
One moment. Amendment L003 is displayed. To the amendment, Rep. Brown.
Thank you, Madam Chair. This bill, this amendment is a small clarification that we caught through some additional stakeholding that makes sure that when a carrier is making decisions about pre-licensure candidates and whether or not they can be compensated, that they are posting their applicable requirements online. We ask for an aye vote.
Is there any further discussion on Rep. Gilchrist?
It is to the committee report. To the bill? Sorry, Madam Chair, just
Rep. Brown.
clarifying, we're still on the committee report right now, right?
Yeah, we're still
Okay,
on the
great.
committee report.
Okay.
Yes.
And the amendment is to the committee report. Okay.
Yes.
We ask for an aye vote on the amendment to the committee report.
So is there any further discussion on the committee report? Seeing none, the question before us is the adoption of Amendment L003. All those in favor say aye. Aye. All those opposed, no. Amendment L003 is adopted.
Oh.
Representative Brown.
Thank you, Madam Chair. We ask for an aye vote on the committee report.
Members, the question before us is the adoption of the Health and Human Services Committee report. All those in favor say aye. Aye. All those opposed, no. The Health and Human Services Committee report is adopted. Rep. Gilchrist to the bill.
Thank you, Madam Chair. Thank you so much to my colleague, Representative Brown, for the amazing work that he's done on this bill. I'm proud to present it today, House Bill 1002, which is aimed to improving access to behavioral health services in Colorado and strengthening the workforce. I've heard from many Colorado families who can't find behavioral health providers despite having commercial insurance coverage. Many times the providers they reach out to on their insurance directories are not available, not accepting new patients, or not actually in network. These ghost networks make it harder for patients to find care. Can you imagine being a parent of a child who just experienced a mental health crisis and you're given a list of providers to call and you spend hours calling one after another with no luck? Your kid's in crisis and now that situation is worse because you can't find a therapist that is covered by your insurance. The U.S. Senate Committee on Finance conducted a secret shopper survey to understand ghost networks and released a report which found that only 50% of the calls made to Colorado provider listings resulted in a possible appointment for a new patient, for the patient. I've also heard from behavioral health providers who want to be in network with insurance carriers, but after they apply to be in network, they don't hear back for months, and then those providers are unable to serve insured patients, and our communities lose access to covered care. Coloradans are 11 times more likely to see an out-of-network therapist than a comparable physical health specialist. This creates higher out-of-pocket costs, delays in care, and other negative consequences for patients and families. This is why we're bringing this bill forward today and to take the first step in addressing these pressing issues.
Representative Brown.
Thank you, Madam Chair. And I want to thank my colleague from Denver for her amazing work on this bill. I really can't thank her enough for her partnership. Members, I will say that this bill is an important step forward in making sure that we have timely access to mental health care by addressing some of our mental health workforce shortages. The bill tackles timely credentialing by directing insurance carriers to complete credentialing for mental health and substance use providers within 60 days, consistent with existing law for physicians. We are addressing ghost networks by asking insurance carriers to confirm provider participation at least once every 12 months for providers who haven't submitted a claim. And we are supporting pre-licensed providers by allowing them to be reimbursed for services that are delivered under the supervision of a licensed behavioral health provider. Finally, we are revising the hours for a social work candidate so that it aligns with the National Social Work Compact. These provisions create a clear, standardized, practical framework for commercial insurance participation for mental health substance use providers, and we would ask for an aye vote.
Representative Barone.
Thank you, Madam Chair. Members, I rise in support of this bill. I heard this bill in committee, and I want to commend the sponsors for getting the diverse spectrum of stakeholders involved in this bill into a good place. This bill will specifically benefit rural Colorado by making sure the individuals working towards their licensure, who frequently serve in rural communities, are able to get reimbursed for their services. I've also heard from my community, mental health workers, about the challenges of getting their behavioral health providers in network with insurance carriers they work with. This bill streamlines the process so providers will hear back from insurance carriers in 60 days. The same timeline they need to respond to doctors. So this is a good bill. It's good governance. It helps out rural communities. I urge an aye vote on this bill. Thank you.
Is there any further discussion on House Bill 1002? Seeing none, the question before us is the adoption of House Bill 1002. All those in favor say aye. Aye. All those opposed, no. House Bill 1002 is adopted.
Madam Majority Leader.
Thank you, Madam Chair. I move the committee rise and report.
Members, you have heard the motion. If there is no objection, the committee will rise and report.
The House will come back to order. Mr. Schiebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to report is under consideration, being the second reading thereof and making the following recommendations thereon. House Bill 1002 is amended and 1026 passed on second reading or engrossed and placed on the calendar for third and final passage. House Bill 1110 as amended laid over until March 4th, 2026.
Members, there are no amendments at the desk. Representative English. Thank you. You have heard the motion. The motion before us is the adoption of the report of the Committee of the Whole. Mr. Schiebel, please open the machine and members proceed to vote. Representative Bradley, how do you vote?
No.
Representative Bradley votes no. Representative Slaw, how do you vote?
No.
Representative Slaw votes no. Representative Flanell, how do you vote?
No.
Representative Flanell votes no. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representatives Brown, Clifford, Sirota, Smith are excused. Please close the machine. With 38 aye, 21 no, and 6 excused, the report of the Committee of the Whole is adopted. Members, additional announcements and introductions. Representative Zokai.
Madam Speaker, I would like to request a moment of personal privilege.
So approved.
Thank you, Madam Speaker. با اینکه تو آمریکا زندگی میکنم دلم با ایران عزیز میتبه و الان قلبم شکسته. Members, this past weekend brought a complicated range of emotions for me. Ayatollah Khomeini and Khamenei are responsible for unspeakable cruelty against the Iranian people. They have the blood of tens of thousands of Iranians on their hands and have oppressed women, and on a personal note, are the reason my family had to flee their country, leaving behind all of their belongings. And by the time they were able to return, it was not the Iran that they knew. And so for me and for every Iranian I know, the news of Khomeini's death was one to celebrate. And at the same time, we know that the Iranian regime is not just this one individual, and it is backed by a powerful military, and that regime change cannot happen with one airstrike, and that American imperialism has never resulted in successful regime change, and our invasion into the Middle East has only resulted in high death tolls, in instability, and leaving the region with even less humanitarian rights. And I fear that we have become numb to the reality of war. That in this careless action, we bombed a school that has left over 100 little girls dead. 100 dead children, and it feels like a footnote when we are talking about this action. It truly feels like we are glossing over the humanity of Iranians. Whatever your feelings are about this, to the parents of those children, that loss was everything. And when I hear from family who are scared, whose homes are shaking from bombs going off nearby, when I hear about babies being rushed out of the NICU because a bomb's about to strike, hospitals gone, airports gone, so people are stuck. I just wonder if we are keeping that in our minds as we talk about this conflict. And I wanted to share that because that is top of my mind. And it's a weight I'm carrying with me as the only voice for this community in this chamber. And it's not surprising that I do call for no war with Iran, and that I am asking all of you to stand with me in calling for no war with Iran. And if we can't agree on that, I ask that you remember the human toll of these actions. And it feels a little maddening to have to say that. But when I look at the coverage and the way the discourse has played out over this, I do feel the need to say that. And so I appreciate all of you who are standing with me, who've asked me how I'm doing. This is a difficult and also complicated time for my community. And I appreciate all of you and ask that if you want to have that perspective, that you come and talk to me. I'm open to talking about this with anyone because it is very difficult when we are told that we are being bombed our way into peace. Thank you.
Madam Majority Leader.
Thank you, Madam Speaker. I move to lay over the balance of the calendar till Wednesday, March 4th, 2026.
Balance of the calendar will be laid over until tomorrow. Madam Majority Leader.
Thank you, Madam Speaker. I move the House stand in recess until later today.
The House will stand in recess until later today.